again, just for clarification, in an RFP, as opposed to the new section that has price, we can't even look at the second and third offerers to see what their price was. And that's always been my challenge, is how do I know that, what is my starting point? I could have a couple of extremes but not even know it, or my winning offerer might be the extreme but I wouldn't know it. So that's always been the problem that I've had to face, and I just said, okay, well, this is the highest ranking and I can't open the price, and then we return the unopened sealed envelope. And I just, that still bothers me, but I guess now with the competitive seal proposal, I guess I could then put price as a factor. Just some historical discussion.
Right. Yeah. And I think the previous discussions that we had was that we basically have the three source selection methods. On the one end of the spectrum is we're looking for the lowest price, and that's in the competitive seal bidding, invitation for bid. On the opposite extreme is the request for proposal, wherein we're looking for the best quality or qualifications, and then we talk price later. And so now with the new source selection method is the competitive seal proposal. That's kind of like, I guess, the middle of the road, wherein price is taken into account during the evaluation process, but it's not a determining factor. Okay. Any?
Thank you. I guess I just have questions on that, in that the RFP is now being limited to solely licensed services?
No. So at the last roundtable that we had last week, that's been changed, and it is now we deleted the word licensed. And so if you take a look on page 17, it will now read
just
conditions for use. The professional services specified may be procured.
Right. I guess I view this price, not being able to consider price as a factor for certain professional services versus other services, as very limiting, particularly when there are procurements that don't involve the government paying, particularly for services. I'm thinking about things like the airport's retail space. Price was a factor there because they were bidding on retail space and professional retail services for duty-free, and they were offering a price to the government. I don't think this takes into account those types of procurements.
That wasn't was that an RFP or a multi-step bid that they had?
It was an RFP. It was an RFP.
Yeah, I don't know, but in any event, the new RFCP provides a model for dealing with that. And so it's felt that
right.
we don't put so much pressure on the RFP process anymore.
Right. I think it's difficult for me to see where that line would be between RFP and RFCP. RFCP is some services, and then RFP is professional services, but for certain professional services, we're going to want to cut out those really just, you're too high priced. We can't afford that.
And if I understand it correctly, I mean, after we've ranked the proposals, then we sit down with the highest ranked offerer and we talk about price. And at that
Yes.
time, we can either start, I guess we are able at that time to negotiate, well, then we want to bring down the price to within what we can afford, so let's take this out and let's take that out. Right?
So what I envision happening, say this is for like an anesthesiologist for GMH, that would be some sort of very professional services. And if you can't consider price at the outset as part of the factor, or as a factor, you're gonna go in, you're gonna issue this is going to create a lot more work for the agencies. The agencies are going to issue their notice of best qualified offerer. You're the best qualified. Then they're going to enter into negotiations. Then they're going to find out that this person is just so far out of the price range that they can't talk to them. Then they're going to have to issue another note, and the negotiations are going to take a while. Then they're going to find out, oh, we could never afford you in the first place. I'm sorry, we're going to have to now reject you, go to the next qualified offer, and then maybe they find out the next best qualified offer is also out of the price range. And then after more negotiations, and then issue another one. You know, this is being able to consider price allows you to figure out if you even have any candidates in your price range.
But that's the way the law is now, and that's the point.
Well,
That was my point.
Yeah, currently.
Yeah, I mean, but that's what we're saddled with.
Currently,
So-
you can.
So the other extreme, not the
You're not obligated to use the RFP services for acquiring anesthesiologic
I'm
services
just
anymore.
trying to-
You will have that opportunity to go through the RFCP process because it's no longer required to provide. We took the shall out in RFP service and put in may. So it's the agency's determination to choose which method of source selection is most appropriate
But the
for them.
RFCP process, the statute you have in here says that you cannot use the RFCP process if another process is applicable.
No, both of them say may. You may use it unless there's another one that's applicable, but the RFP is not necessarily applicable anymore because it's no longer mandatory.
Well, so you have your RFCP process, which says you can't use the RFCP process. So this is going to be so difficult. This is just going to be so difficult.
Well, this is where the AG's office is going to have to come in for private.
We're going to have to be involved in every single procurement because honestly, even I can't figure out when something is going to apply. So you go to IFBs. IFBs say that the competitive sealed bidding method is the preferred and default method of source selection authorized for any solicitation for supplies, services, or construction. So this, if you go to section 5210, IFB is the default.
And this is where the vast majority
And
of Guam
for supplies and services. So it's the default. And then you've got your RFC process that says, well, you may apply it if something else isn't applicable. But you've already got a law that says that IFP is the default.
I guess I would interpret that to mean that if we're not sure, at the end,
This applies whenever some other selection does not trump. So when does the RFCP trump the IFP method, and when does the RFP method trump the IFP method or the RFCP method? I can't tell you. I don't have an answer. The way I read this, IFP method is the trump method, and then RFCP may be used sometimes, and then the RFP may be used, but when? I can't, because IFB method is default.
I agree with her comment that the IFB is by default because that's where GovGuam does purchase the vast majority, probably 90% of all the things that it does. and this was the kind of the gray area where we were stepping into the RFCP method, and I think it's going to end up being, quote, a judgment call. And this is where I think with the passage of this law, and then when later on with the regulations, this is kind of, in order to get price, we have to go through this method. And so from my perspective, I would like price to be a factor in the RFP method. And I guess in order for price to be a factor, I have to go that route as opposed to not making price a factor.
And we agree price should be allowed in RFP. But I think the real question is, now you have specific language. We did not have specific language before that said the IFP is the Trump default method. And now we've got this new language for RFCPs and RFPs that says, oh, you might be able to use this if something else doesn't trump. But we already have a statute that says IFP trumps.
The existing language says, unless otherwise authorized by law, all territorial contracts shall be awarded by competitive sealed bidding.
Yeah, unless
that's the default. That's the default
authorized.
version, and that's the one that we have had since the beginning.
Right.
We have had the RFP since the beginning,
But
and neither one of those has created any major difficulty in the utility of them, other than the fact that those are the only two we had, and we were trying to put square pegs into round holes when we got to services that were not particularly professional and complicated projects like the sale, maintenance, all of that. So that's what the RFCP is meant to alleviate, is to take the pressure off of trying to put those into those places. You have three choices. It's just like when you go to Article 5, when it talks about the various kinds of management contracts that are contracts that are allowable in construction. And they said it's in the discretion of the agency to pick the type of contract that they think is most appropriate for that particular solicitation. The same thing applies here.
I absolutely agree that the old language did not create any problems. The old language just said, unless otherwise authorized by law, you can use one of these other methods. Unfortunately, now you have added a B, and you have added new language that specifically states the IFB is the default method. That language did not exist in the current statute. The current statute does not say
so we're going back to the beginning
IFB is
again?
default.
Is this what we're doing? We
No,
thought when we sat down we were going to start where this is the ground we have covered how many times, and here we go again.
Well, it's part of trying to figure out when you can consider price. When can you consider price as part of, and when can you use the RFP? Because now we have a new B that says IFB is default. It's specifically the new language that was added, specifically says that the IFB, which is price only, is the default method for services. That isn't, the current statute doesn't say that. This new B and the added language says that this is the preferred and default method for services.
To have it deleted?
Oh, I think you can't have an RFCP and an RFP process that says it's may, you may use this unless something else is applicable, because we already have something now. Now the new language says something else is applicable. It says the IFB process is the preferred and default method for services, and it doesn't distinguish between professional services or any services. So when can we use the RFP? And if you're saying that this is going to be some sort of discretionary call on the agency's part, where we have lay people, we don't have attorneys making these calls, and they're not required to get the AG's office involved when they issue the solicitation unless it's over $500,000. They don't have their own personal attorneys advising them, okay, now use the RFP process. now use the RFC process. And unfortunately, we have this new language that says the IFB is the preferred default
where
method.
Where is that language that talks about, that uses the term default?
It says, it's on page 4, 5210. Section 5210, section 3, the new section 5210. 5210B. The new language says the competitive sealed bidding method of source selection is the preferred and default method of source selection for any solicitation for supplies, services, or construction. Includes all services. It doesn't distinguish between any of the services. So for the professional services, that would be included.
Well, I don't know. My reading of it, on that line 23 there, all other methods allowed by this part shall only be used in the circumstances or on the conditions specified. And so like when we go to the RFCP...
And then it says may. It says may. It doesn't say, okay, in this now will trump the IFB. It says, so you've got a default. IFB is default and preferred. And then unless you have certain circumstances and conditions. But then you go to the RFCP and it says, oh, you may use this sometimes.
Okay, well,
and then RFP says,
okay,
well,
so even taking it apart
you
now,
may use this.
Now, maybe you can suggest then how you think we may be able to address what you see to be inconsistencies. I mean, I just, again, you're correct in that on page 4, line 20, it says that the competitive sealed bidding method of source selection is the preferred and default method authorized for any solicitation. All other methods allowed shall only be used in the circumstances or on the conditions specified.
Yeah, only.
So when we go to, for example, the competitive seal bidding process, it does outline when it can or
cannot be used.
Where did I see that? Help me out here, John.
Page 8.
Okay.
Where it talks about the quality and competing products may be compared and trade-offs made between price and quality of services offered. It should not be used when another method of source selection is required or is appropriate.
Is that supposed to be an is?
Yeah, that was changed at the last meeting.
Okay. Yeah, so this already says IFBs are default. And then it says this cannot
But
be
default
used.
means it's your last resort. If nothing else works, you use an IFB. You're not left with...
It's not last resort because it says it's also preferred. It's not last resort.
That's in
it's your
keeping with the
first
original
method.
language. It said that...
You said preferred.
We kept the initial language in there about the competitive sealed bidding shall be awarded unless otherwise authorized by this chapter. You have to use the IFB. That's existing. That's been the law for 30 years now. And it wasn't, we're chastised for making changes to language. The language already says that.
It doesn't say it explicitly like this. So now, when I look at what source selection, so I'm going to get a contract to review, and this is from the agency and AG perspective. I get a contract to review, and one of the first things I look at is, did they use the correct method? Did they use the correct method for this? Was this a supply or a service? And currently, IFB is the kind of the default, unless otherwise authorized by law. And then you have other sections that say, oh, these methods are authorized for these things. You don't have this specific language that not only says it's the default, but the preferred. So now I'm going to look at this contract that I've received, and I'm going to say IFB is not only default, but preferred. It is the number one method. It is the preferred method. It is the first method, and any other methods can only be used unless it's specifically stated that they're supposed to be used. When I get to 5212, it doesn't say, okay, you don't have to use the IFB method here. It says, it's still got this language, and it says, you cannot use when another method of source selection is appropriate. Well, we already know that the IFB source selection is preferred and appropriate. So I've got language that says IFB is preferred and default for all services, and then I've got a competitive sealed proposal section that says the competitive sealed proposal cannot be used if another method is appropriate. So I'm not going to be able to, I'm going to have to say, I'm sorry, the IFB method is preferred and appropriate, so you cannot use the RFCP process.
I recommend we take out the language in B altogether, leave the rest of it as it is, and move on.
Where and what page?
I would
on
agree.
page 4.
I would agree. That would make it much easier for me to tell if an agency has used the correct method.
Okay.
And then all the permissive language.
Are you saying, John, just so we won't have a B, all
Won't
of
have a
B?
B.
Oh, okay.
I mean, I think that leaves the government in as much of a lurch as it's made out to be through this
It just
discussion
turns
about
us-
have default and preferred. I mean, it was already pretty well said when it says, unless otherwise authorized, all territorial contracts shall be awarded by competitive sealed bidding. That is a default method as far as in my language and my interpretation of it. But in order to move away from that, just eliminate B and let's move on. And please, let's not go back and cover ground that we have covered and recovered and recovered.
I'm sorry if it seems like I'm doing that. It's kind of part of the when do I figure out if price was supposed to be a factor or not.
All right. So I think John is proposing that we delete lines 20 through 24, and I think then I presume that addresses the concern that you're raising, right?
Yes, but we have a second. We support the OPA's position that price should still be a factor in RFPs. It really allows the government to figure out if something's within the realm of possibility before we move forward.
But I guess it's offering it to the RFCP.
But it's a little unclear, professional, not professional, other services.
For the last 30 years, they've been using the RFP method to rank, start with the top rank, negotiate price. If that doesn't work, go to the second best. And this is the first I've heard that this is somehow a critical issue in the government, and they just don't know how to deal with that.
It's not a critical issue, but it is a factor that has been worrisome. And we've just kind of like accepted it because there has been no change. So I think from that perspective, having this other area is appropriate, because that is the concern I have, because I would like, to some degree, price should be a factor. And so my only hesitation on the RFCP was it's a new thing. We're probably going to have some appeals on it, protests and appeals, because anything new is going to have that. That's just the nature of the game, right? Yeah, until you kind of test the waters through opinions, So I guess we'll be prepared for that. But I think moving in the direction to have price as a factor for professional services is in the right direction.
We agree. And I believe Laura attended last week and raised that issue. It really comes into play more with our federal grant funding.
But price for professional services is then taken into account in the competitive seal proposal method, right? And if that is not to be the consideration at first brush, then the RFP would be the.
Well, if I had to project into the future, I would think the RFCP will become the method, and the RFP will slowly die.
That actually has been the action that was taken by the ABA Model Code. They've eliminated the RFP method altogether.
Yeah.
And you do everything under the RFCP.
Right.
But it was felt that people are familiar with the RFP. They may want to use that until they become more accustomed with the RFCP. So it was a bit premature to just go ahead and wholesale repeal it right now. But that's probably the future.
Yes.
So we'll go ahead and we'll go back to page 18 and pick up where we left off last time, and that was basically just to come to agreement on that line 19 through 21. Price is not a factor to be discussed, although the OPA has raised their concerns about that.
And we agree with those concerns.
Okay.
We would like price to be a factor, particularly for federal grant funds, where we have some very strict requirements and we have to follow those. And prices
has to be a factor.
Well,
has to be a factor. For certain grant funds, price has to be a factor.
At the federal level, price is as important as is the local level, and the federal level allows price to be determined so long as it's fair and reasonable, and that's what we require here. And fair and reasonable pricing requires that people give their costing as part of their offer. It's all in the regs already. So you have mechanism to determine whether the price is fair and reasonable based on an analysis of their costing and their audited records and such, without having to have competition. The federal law makes it clear if you have things like competition that determines price is going to be a very good price, you don't have to have that kind of price competition. As long as there's a mechanism that determines it. That's what the whole federal schedules are based on. They're tightly negotiated prices, so you can pick anybody. Just pick anybody on the list. It doesn't have to have a competition element to it. But the new method is meant to cover this, and I just think that let's keep it the way it is. I mean, this thing was built on, the RFCP was built on an old-fashioned notion that professional services are worth their weight in gold, and when you need professional services, you need the best that there is, and then you negotiate whether you can afford it and is it a fair and reasonable price. We've been doing that for 30 years. You want to change that now? The people won't know whether they should be using the RFCP or the RFP. You talk about a quandary, you're going to have that same quandary if you interject that same kind of price element in this.
I don't think she was saying that.
Yeah, I wasn't saying that. Yeah. No.
Okay.
No. And another to address. Oh no, thank you. No, thank you. No. You're exactly right. That wasn't. But to address that, what I foresee happening is if we cut price out and we can't even look at someone's price, we might want the best of the best services, but not be able to afford them. And what will happen is if you can't look at any price part of an RFP for top of the top professional services, we're going to end up canceling a lot of RFPs, and we're going to issue, you're the notice of best qualified offerer, and then we're going to issue our letter of ranking to the other offerers. You are the best qualified. We are going to begin negotiations with you. You other 3 bidders are number 2, 3, and 4. We we conduct negotiations only to find out that all 4 are too far out of our price range.
So
which
that's
happens,
when,
and then we have to cancel it.
well, so then that I
And
think
that-
that's when we go back to the drawing table and find out that maybe we're wanting to buy more than what we can afford, and we have to then bring our specification requirements.
True, but we're not
into
going to
budget
find
reality.
that. We're not going to find that out until we've already conducted negotiations with 4 offerers.
That would depend
found
some-
out that they're all out of our price range, canceled the RFP, and when you cancel an RFP, and you've already told someone you're the best qualified, they're going to protest. It's just going to be protest. They're going to say, I was the best qualified offer. You told me I was the best qualified offer. And then you'd conducted negotiations, and everyone was out of the price range. So, and we cancel, they're going to protest.
Okay. John?
Yeah, if you take price into consideration, you eliminate the whole notion of ranking based on best qualified. So you're no longer going to rank them on best qualified. You're going to rank them on price. You're going to rank them on factors. That's what happened in JFK. And then we have in the RFP process.
No, JFK price was not a factor.
But it was.
No, I beg to differ. I'm just correcting from the appeal process. Okay, price was not even known.
That's how they got to be the preferred offer.
No.
It was an RFP.
Yes.
Turn on your mic.
Yeah.
Yeah, but price was 70%. Price was of 70% of the factors to be evaluated and determine whether you're the most qualified.
No, I don't recall that.
Well, okay.
Okay.
Yeah, but if price were, let's take that, if price is a factor and you say it's worth 70% of it in an RFP, then you're not really getting the best qualified. You're getting the one who comes in with the best price at the offer level. And then the RFP requires you go through a process where you negotiate fair and reasonable compensation. So you've already determined that they have a price. That got them to be best qualified, but when you start talking about fair and reasonable compensation, they can bid it up. And so there's no point in going through a ranking and then a negotiation for fair and reasonable compensation if price is the factor that you're going to be most concerned about in an RFP. So you might as well eliminate the whole RFP method,
We're not saying
or you're
that-
going to end up with a lot more protest over the evaluation factors than you see so far.
We're not saying that price is going to be the primary factor. We're saying price is a factor in determining whether we can even go through with
Well,
it.
price-
If all of so if we can do an RFP and for professional services, and up front we can see all of these offers are going to be far out of our price range, we can simply cancel. And then
But that's the whole.
before we tell anybody you're the best, we're going to negotiate with you.
Right. Sure.
Well, that was just my whole issue. I could never see the price.
Yeah.
That's the whole issue right now. So I'm not sure where I see where you're coming from. Okay, because that has always been the concern. Is I could never see the price of the other to even know we were in the ballpark. I'll give you an example. There was one we had for the RFP for audit services for CLTC and ALTC. We went to 3 rankings 3 times because in the first time nobody bid. Nobody submitted a proposal. Then in the second time, we had one proposer, and it was in the 6 figures, and we said, no way, we can't afford that. So we canceled it again. We did cancel because it's only because we had one offerer
Right.
that we could open the price and then just evaluate. And so when we saw that the price was way out, we had to cancel again. And then it was on the 3rd try. We had 2 offerers, so we had to rank the 2. So I could not know what the second ranking was, but the first ranking was okay. It was within the budget of what CLTC could afford. And so then we selected, but we had no idea because we never did open the second offerer's area. So that is the way it works right now.
Yeah.
And that's always been my concern. How come I can't open that envelope?
That's exactly it. And this and keeping it where and explicitly saying no, now price is not a factor. It changes where the cancellation of the RFP could occur, and offerers are much more upset about a cancellation if they've already been told they were the best qualified and you've already negotiated with them. But if you cancel it up front and say, if the cancellation can occur earlier, saying we really couldn't afford this, because you can see the price, which is, I'm agreeing, we want to be able to see that price up front. So if it is far out of our price range, we can cancel at the earliest stage rather than after we've had to go through.
It just doesn't seem logical that, in the RFP process, if somebody's going to protest because I disqualified him despite the fact that I said you're the most qualified, if I can't afford you, it doesn't matter whether you're the most qualified, but ultimately at the end, price,
it really affects where the cancellation occurs.
All right, I would like to maybe bookmark this, and let's move on to the next topic, and we can come back and revisit this phrase. The sentence, price is not a factor to be discussed or considered until after the ranking. It seems that that's where we're getting basically wrapped around the axle. So
that's what we do anyway.
What?
That is, just for clarification, that's what we do anyway.
Yes.
We do that anyway, so I'm not sure what the issue is.
We do what anyway?
We rank.
Right.
Mm-hmm.
And we rank.
Right.
And then once we rank, what I'm trying to say is, I'm not sure what the issue is, because that's what we do. It's correct. This is what we do.
Yeah, I understand. But what you're saying is you want to be able to open up the qualifications and open up their price at the same time.
Or have price be a factor. Which
and
is
it is a factor after we've ranked the.
I'm not. So I think what I'm saying is getting a little bit I think I'm not saying it correctly. I'm agreeing with the OPA that we would really like to see the price, and that would help us not have to do so much legwork only to find out later that we can't that we can't afford it. We would love for price to be a factor, so we could see it front, and we could cancel things earlier rather than putting more effort and time, government resources, into it only to find out that we can't afford it. And that's what we currently do. So we would like to change that.
So are you saying we can open up, like for instance in the example I used where I had 2 offerers, I could open up the second offerers? Is that what you're saying?
No, just being able to use price as a factor, or
but
one
price
of.
is a factor in the new method.
It is in the new method, but for professional services as well. We should allow it for professional services.
I'm a little bit confused now. I think we do need to bookmark
let's
it.
bookmark
Yeah.
this.
Okay, I'm a little bit.
I guess it's more, where's the line?
Why don't you come back maybe with some suggested language that we can ponder upon?
Okay.
Yeah, I think
That might be
would-
a good idea.
Yeah, some suggested that we could ponder, and maybe send it as an email for that section. Yeah.
So we move on to page 19 on section 10 regarding the procurement from nonprofit corporations. And I think on this one, the question was posed by the OPA as to whether the nonprofit corporations have to be competitive. And I think we put in the language there on line 19, page 19, that first of all the prospective contractor must be responsible and responsive. And I think that address.
No, my concern is the word without competition on line 18. I would propose that we just delete that and just let it stand. because just implying you could get something without competition sends the wrong message overall. So I would just propose to delete the words when is responsible and responsive. So it's the word without competition that I think should be deleted, and I would propose. Other than that, I'm fine with the rest of it.
So then what benefit does being a nonprofit corporation have then?
Well, you could conceivably have two nonprofits.
And then it addresses that in here that when there is two nonprofits, that then where's that in here?
See, page 20, bottom.
On C. In the event more than one nonprofit prospective contractor should provide a notice of intent to avail of the right to obtain a contract without competition, the eligible prospective contractor shall compete amongst themselves pursuant to the method of source selection identified in the solicitation.
But I guess the concern that I'm raising is getting just the word without competition is like sole source, which to me are anathemas. It's just my predisposition against those kinds of words when it comes to procurement. Procurement should be open to everyone who wishes to compete, and whether or not you have you could have a situation where you have a service organization, I won't name names, who may want to do the same thing competing against a nonprofit. So by default, you're going to give the nonprofit that advantage, which I don't think may be good to do.
So then we should do away with the advantages that's given to women-owned, minority-owned, veteran-owned.
Those are policies. I'm not saying a nonprofit. I just don't like the words without competition.
So perhaps you can give them like a advantage, but
Yes.
but without competition. We're in a situation now
Yeah.
where we're forced to work with a nonprofit, even though their pricing is way above market,
Yeah.
and so we're having to spend much more money because nonprofit wants to compete. Well, I guess not compete, but do the services, and we don't have any wiggle room to negotiate.
Okay, well,
Yeah.
I mean, you bring up a...
And maybe that's where an appoint advantage or something, but the words without competition, I mean, if a nonprofit, why should, just because, well, I understand the policy implications where you want to give people with disabilities and other advantages. I understand that. And that's kind of like where you would have to do it, like you could give a nonprofit who employs disabilities up to a 20% price advantage. So if their price is no more than 20% of the next one, that's where you could get it. But to say without competition in and of itself, to me, just sends the wrong message to everybody.
And that's existing language right now, the without
Well,
competition.
Okay,
And so...
okay.
Since the 18th legislature.
Okay, well,
And so
I'm just now...
And I would suggest
I-
that we change it.
Yeah,
Just because
it has been there doesn't
we
mean
have
it-
practical experience.
Yeah.
This would be one of the ways that we could change the law
Yeah.
to
Just
help the
having
government
without is to
by
me just
not-
anathema.
yes, it's that without competition language that is. We could propose a change to this section that gave them an advantage, or maybe
so how does anyone
so
propose?
long as they're
Okay.
and
So if this is...
well, this is so.
If this is, if people are finding, having concerns with that without competition, then how do you propose then?
Well, you proposed it from a price perspective, that the non, and it's in another section because we were just looking at this when it came to delivery, shortened delivery, price is still preferred over a shortened delivery under so-called planned procurement. It's under planned
Yeah,
procurement.
there are models of that in policy in favor of service-disabled veteran-owned
Yeah.
businesses where they have 105, they have a 5%
Yep.
preference. Local preference has a 15% preference.
Yes.
And so there are models for that already in the code. This non-comp is usually, I mean, it really is an outlier, but I think that you're going to have to give notice to all the nonprofits out there that this is being considered, because so far, I don't think anybody has been aware of that, and I think you're going to.
I was not aware of it now until just reading it.
Well, I mean, as I said, that non-compete has been part of the law since the 18th legislature. So this would be a major change. I have no problem with taking it out personally. I just think that it's going to be a political bun fight if that's what you want to do. I don't know how extensively these things are used, but you're not the only ones I've heard from. I get an ear from GCC and other people saying, "How do we deal with this?" You know, so I'm not opposed to it, and I think a thing would work, but we need to hear from the nonprofits, see what their take is.
Well, I think to stem that negative response, what you could do, clearly the purpose of the statute is to employ as much as possible disabled persons through government procurement. I think that's really the underlying policy, and I don't think anybody disagrees with that one. I think it's a good one. And I've always disagreed, for starters, with the title of this particular statute. Number one, it's deceptive. It's not just any nonprofit. It's a nonprofit with or employing people with disabilities. I think that, and we've kind of evolved now since the 18th legislature to the point that with the Americans with Disabilities Act, disabled persons no longer have to find a special nonprofit that specifically employs them. They could be employed anywhere that can reasonably accommodate them. However, if you want to fulfill the policy, you could say preference for having a certain percent of disabled persons, regardless of whether you're a nonprofit or just a regular company. And I think that would expand the pool of people that would qualify for the preference, and also encourage more employers, just normal employers, to hire disabled or people with disabilities, especially if they're engaged in government procurement. So I think overall, to expand the number of people or entities that can participate in this preference that you're creating, I think that would be a positive that would possibly negate some of the negative factors of taking out the competition clause here.
And creating a preference is kind of a nice compromise, right? Currently, if you have one of these nonprofits bid, they automatically win, regardless of whether it's good for the government or not.
Well, the way I read it here is that if a nonprofit steps up and files an intent that they want to take part, everybody else gets pushed to the side,
they're
and
out.
they get it.
Yes.
What you're saying then is that we basically reword this so that they are given preferential treatment or some kind of preference.
Usually it's a price point preference. It's
Up to
usually
like 10 or
priced up to
20%.
yes, something like, so there's a current local preference up to 15% price point, or veterans 105, like 5%. So it's usually done as a price,
Okay, I see
which
what you mean.
kind of goes back to
That's where
why
they get
you
the
want to
advantage.
keep price as a consideration in RFPs, because it's very hard to give that price preference to local companies and even these nonprofit corporations if you can't consider price. You can't give them the preference if you can't consider price. And this is for supplies or services. So, in IFBs, obviously you can always award and you get that preference for price. For the services, it's going to be questionable how you can give them that price advantage.
Okay, so I'm going to bookmark this, and we'll go back and take a look at putting in language that takes away this without competition, but will provide
There's already statutes, like the local preference statute, which has a 15%. It's got language.
Do you have that particular citation?
Yeah, it's section 50, I was just looking at 5010, I think. No?
But the problem with that, you have to specify that, because local preference applies when you have company X on Guam and company Y is from off island, okay? But if you have two companies that are, and they're both local, it doesn't apply.
Right.
So you could conceivably have a local preference company, a local company and a nonprofit company. So you want to give that nonprofit company the price point advantage, is all I'm trying to say for clarification.
Okay.
And you could structure it, I think that's a good suggestion. You could also structure it so that same, if you have two nonprofits with employing people with disabilities, then no advantage.
Right, and at that point, then it comes down to a purely competitive.
Yes.
Who's got the better price? Okay. Yes, Ann?
Yeah, you'd have to specify as well. Here, it just says if you're a nonprofit, and then it doesn't specify a percent of persons with disabilities they have to employ. It's just that persons with disability have to, and I'm reading out of page 20, section B1, they have to certify that persons with disabilities will be employed to basically supply or perform the service being solicited. That's all.
Right.
Supervisory personnel don't apply. To actually broaden this, you can say have to employ X percent of disabled persons from Guam who will work on the contract or something to that effect, and that would promote literally the hiring of disabled people more so than the statute as it exists today.
Because you don't want the token one person. That's the point. You want a percentage. And what's an appropriate percentage? I don't really know. But you don't want the token one person.
Isn't there a GovGuam employment statute about agencies being encouraged to employ persons with disabilities? I don't know if there was a percentage in that, but I know we have an employment statute that encourages the GovGuam agencies to employ persons with disabilities. But
yeah, but I think it's just like a policy. It just kind of
it's just a policy. There's no number.
Yeah, it's in the FLSA sections, right? And I think it just encourages.
Okay.
I'd like to see some models drawn up by people proposing this change.
Okay, so one from Jessica and one from...
We'll look it up.
Okay.
Drafting.
Okay. So with that, we can move on to, unless there's something else in 5217 that needs to be addressed, but actually just the highlighted part was the one that was somewhat contentious from the previous roundtable. And if we move on, if there's nothing there, then section 12, there didn't seem to be any concerns on section 11 of the bill, unsolicited offers. But when we get into section 12 of the bill, section 5220, then there were concerns about, we added in new language. And this was really more clarifying because we talked about GSA as the one procurement authority for services and supplies, DPW for construction, or agency. So we got autonomous agencies like GPA agency issuing the solicitation who have been granted or delegated authority to perform their own procurement functions. So it was just a clarifying language.
Well, I think on page 21, for the unsolicited offers, I think you do need for that one to, on page, or line 21, page 21, delete the language issuing the solicitation, because this is for an unsolicited offer, so ostensibly, there's no, I know you did that for all of them and that they do apply, but here, for the unsolicited offer, there is no solicitation now. So you can just put purchasing agency, and you'll achieve the same effect.
Okay. All right. Page 22. Page competition required. The most appropriate competitive method of source selection, particularly specified in 5210 of this part. Oh, we're still under unsolicited offers. So I guess it's when we receive an unsolicited offer, it has got to be put out, and it seems like a viable offer, and then we have to put it out for competition.
That's correct.
Yeah.
That's the way it's always been.
Correct, yeah. All right. We go to section 12, and there the only, on page 23, we just added new language there clarifying who this, the agencies other than GSA or DPW, but also you have your autonomous agencies who have been granted.
Could I go back to the unsolicited offers? You know, I've always looked at this, the unsolicited offers section, and it says, when anybody sends you an unsolicited, so we're a government agency, and I get an unsolicited offer, it says I shall consider and evaluate the offer.
Wait, what page are you on?
B, processing of unsolicited offers,
yeah.
on page 21. It says, we shall consider and evaluate the offer. It, I think it should be a may. I don't think the government should always have to consider every, and I've always looked at that. That's just a,
Yeah, I would agree with
thought,
that.
why do we have to?
We actually get a lot of unsolicited offers.
And it says we have to consider it, and then we have to, even though we didn't ask for it.
On line 22 of page 21.
And this is the current language, so it.
Yeah, so again, we should, where we see, just like without competition.
Yeah, who may consider.
Yeah, so as a way to improve, let's do
I
may.
thought there was language in here, though, where the agency had to at least look at it, and if it seemed like a service that the agency could benefit from, that then you take it to the next step of putting it out for competition. But otherwise, it will die there at the agency.
But they're right. That's what you're saying is true. The agency's supposed to take a look at it, but that comes from the original language, which said shall consider and evaluate the offer.
Okay. All right. So we change that. Okay, everybody in agreement, we change it from shall to may.
Yep.
All right. Anything else on page 21? Page 22.
Page 22, on lines 5 and 6 on the evaluation. I think on its, that should be just its without an apostrophe. That's just a typo.
Yep. Grammatical.
And here's that shall again. Maybe we put in the event the unsolicited offer is considered, it shall be evaluated at that time, pursuant to the regular competitive proposals.
So it would read, the unsolicited offer may be evaluated to determine its utility. Okay? And we'll keep the prescriptive shall on competition, on the paragraph E, competition required. All unsolicited offers considered as being desirable shall be subjected to the most appropriate competitive source selection, method of source selection. Okay, page 23, section 12. And again, like I said, there, the only change that we really are coming back to visit is the further clarification of agency issuing the solicitation. Or we're talking about those who have been granted or delegated authority to perform their own procurement functions. Because you got an autonomous agency like the port who have not been delegated the authority, unlike, for example, GPA. Okay?
So is it, that was my question for clarification. Is it on GSA's website as well as the ports? Or
No. So if it's GPA that's issuing the solicitation, it'd be on his website.
No,
Because
no,
it
but-
never even goes to GSA.
No, I said Port Authority.
Yeah, well,
See,
yeah, and
because we have GSA also procuring on behalf of fire, health, and all of
Right.
those, and those agencies have websites. So that's where I was seeking clarification.
and I know that on the GSA website you will find all the bids or the solicitations.
But it
from
wouldn't
the
hurt
port.
from a transparency for the agency who is asking GSA to also post on their website.
The purchasing agency.
The purchasing agency. Well, the purchasing agency is GSA, although yeah.
What do you call the one that's
Huh? The end user. So that's where I'm saying, because if you're a vendor trying to find out what does public health want, as opposed to being a vendor who I don't care what the fire wants, what if I could go to public health's website and see what their solicitations are, because I'm a medical supplier, as an example. So what I'm trying to say here is where GSA is acting on behalf, I would like the end user, because even it's GSA who appears and not the agency, to also post on their website.
there is a term that's defined somewhere for that
Yeah.
agency.
Yes.
I read it.
We call it line agencies.
A month ago. Yeah.
We
And
call
they
them
make the
li-
distinction between the one performing the solicitation and the one that's
Requesting,
requested it.
yes.
And
Yeah.
that may be it, requesting agency.
The requesting agency.
That's the
Yeah,
definition.
the
Yeah, it's
agency.
somewhere in the
Yeah,
website.
website of the, issuing the solicitation, which is GS, and the requesting agency. I think that's it, the requesting agency and the requesting agency. That way, public health would have to also post on their website as well as GSA, because GSA will be the mother of all solicitations, whereas public health is going to be unique to public health, fire will be unique to their needs, and they would have to post on their site.
So conceivably then we could find the same information, the same solicitation, let's say for construction services at DPW and at the,
GSA.
no, why would it go on GSA?
No, DPW,
Or the requesting agency.
like Parks and
End user.
Recreation.
Yeah, exactly.
Like
Okay.
Parks and Recreation they're the requesting agency.
Right.
Or let me rephrase, they're the paying agency, because it's coming out of their budget.
Okay.
I just wonder if this is going to create any situations and problems where when GSA amends the solicitation. And
Yeah.
yeah, I know you
Yeah.
can,
Yeah.
but if it's up to if it's the requirement of the requesting agency to post that, how do they even know it's been happening?
Well, that's where GSA is going to have to now,
Yeah,
yeah,
that's
Yeah.
because we don't
it's not
know.
my problem. I just wondered
Yeah,
about that.
yeah.
I agree.
yeah.
I agree with John Thomas Brown that might
But
cause
that's where
you-
GSA has to be sensitive and provide all of that information.
You might have a problem with GSA has certain information and the line agency has certain
the
information,
typical-
and then you have a conflict in the information.
Well, it's a typical problem of trying to keep two accounting books, right?
And
Yeah.
yes, and then you're going to have protests because people are going to say, "Well, I was looking at the paying agency's website and they had this information, and I didn't know it had been amended on GSA's."
Well, the comment would be is that on the agency is for information purpose also, and the GSA is the de facto or the correct one. I don't know, but I think it just helps to show at the requesting agency, so it narrows down what a medical supplier would only want to look at, as opposed to, let's say, a uniform supplier who would only want to look at GP, GFD, GPD.
Yeah.
So what we did at DOE is for the Secure Our School Act and the 100 million CIP, we posted it on our procurement website, but we referred them to the GSA website
Notify
or
them about the
yes,
solicitation
right,
to go
yes.
here.
and we had a link for them to go there.
Yes.
We didn't try to repost
Yeah.
the bid documents and all that
Right,
stuff.
right.
Yeah, if we add this, it might be good to also add a provision that says
For informational purposes only. Yeah.
no, but and then maybe in the statute here we could say in the event of a conflict of information between the line agency and the GSA
Yeah.
agency,
GSA
GSA's the information posted by GSA
governs.
governs. So if we add
Or we
that.
don't add the requirement for paying agents.
No.
Can't you do that in regulation?
Oh,
You could, but yeah, I agree that we're going to have to, if you're going to,
that's
you'd
it.
have to have where the official notice is, or identify this site is the official notice. This
And-
other is just for informational purposes,
yes,
and
yeah.
and yeah, there you have to have a conflicts provision. You have a conflict between this site or that this site
Yeah.
prevails or has the most current or something
Yeah.
to that effect. Yeah, it could be done by reg or by
But again,
statute,
here-
but
Again, here, we're updating the law. We've got, websites were not in existence when this law was passed. Okay.
This law was passed just recently.
5
Right.
to 20, yeah.
Okay.
Okay.
2012.
Done with page 23, go to page 24. Again, on paragraph 2, there's just further clarification of who this agency is,
No, because GSA is the soliciting,
yeah,
the requesting.
the request. No, because you have basically 3, it's either GSA, DPW, or the agency who have
I'm
been
sorry.
granted the
Yes.
authority.
That's correct.
Yeah. GSA or head of the purchasing agency. And I guess that's, well, let's see. And then on page 25, awards shall be promptly posted and maintained for a minimum of 180 days or for the duration of the contract. That was basically brought on by the OPA, 180 days or for the duration of the contract. Okay. We go down, section 12. Originally, we had the procurement of bridge contracts. I decided we're going to forego that this
Thank
time
you.
around.
Thank you. I
And,
remember that
It
one.
was 6 of one, half a dozen of the other.
So we objected to it, so thank you for the deletion.
Okay.
We, so, the bridge contract was kind of generally, I thought the bridge contract was proposed because emergency procurement in this bill is now going to be much more limited. So our emergency contracting is going to be much more limited, but the bridge contracts were kind of proposed as like kind of an alternative to the, it was kind of a check and balance, right? We're limiting your emergency procurement. You can't extend anymore. You have no extension options unless there's a typhoon or an earthquake, natural disaster. But now you can use this bridge contract option. So
my
to
understanding
extend contracts, particularly emergency contracts, and essential contracts. Now that the bridge contract is gone, I think we might need to expand the emergency provisions again.
You want to take a shot at it?
When we get there.
Well, so I'm bringing it up here because I think we viewed the bridge contract as that kind of middle ground, right? We're limiting your emergency procurement, but we're giving you this new option to expand contracts.
No, I think my understanding of the bridge contract as it was originally proposed was when on this day the contract is awarded, but the guy getting the contract cannot turn it over the next day. He's going to need time to bring in his hardware and whatnot, and so the bridge contract was to provide for that transitioning in of the new contractor, and would allow the incumbent to continue providing services until the new contractor is able to settle in.
That was one of the circumstances, but I think what happens in that case is you default to an emergency
Yes.
when you don't have anything else to do, and I think the characterization of this is a substitute for an emergency procurement that makes the emergency procurement legal is accurate. I think that it had that utility implicit in it. There are other circumstances where it wouldn't necessarily be an emergency, but things, it's just that they're not ready to perform, and you want them to, they've won the contract, you want them to take on the contract so you can extend it through a bridge contract. That's all part of it. This is just replete with moral hazard, as we discussed when we went through it, but the feds are working through a lot of the problems with it. They do bridge contracts all the time. All you have to do is, Google federal contracting, government contracting, bridge contracts, and you'll get case after case after case after case on it. And they're narrowing through that case law the kind of circumstances when it's valid, when it's inappropriate, and when it's inappropriate. I think it has some utility. I agree with everybody who said this is awfully scary, because it is. But there's some scary things you have to do to be pragmatic sometimes, and this is, to my mind, one of those times, and it does have some utility in that. But whether it's politically palatable to the legislature looking at this, I don't know, because there's going to be blow-ups in the award of a bridge contract. We're used to blow-ups in emergency procurement. They hardly make a headline anymore, so they become routine de facto. But I think it's better to actually go through the process of intentionally awarding a bridge contract than go through the back door with an emergency procurement.
Which is, I guess, in the case like, I think public health is...
I think public health in the last 3-4 years, almost every month they issue an emergency certificate.
Yeah.
And by really no fault of their own, it was just kind of, I guess, how things are. There's a telecom bid out there right now. That's been on emergency procurement for years, I think.
I think GRTA was also doing that until...
But
Still is.
Well,
Still is.
okay.
8 years later, still is.
Well, I think we all agreed. I think we agreed the last time that, you know, while this may have a lot of utility, the procurement bridges or bridge contracts, maybe we kind of maybe biting off more than we can chew at this time around.
The concern that I had was that this might be a way to just extend the contract without really going out on a true solicitation. That was the concern that I had, that because you had that avenue of, well, the policy of planned procurement was going to be negated because I've got my bridge contract that I can continue to issue. And that was the concern that I had, that this was going to be a way for agencies to continue where they are without bothering. Yeah, that was the main thing, as opposed to the other way. Yeah.
And I think we all share those concerns, but at the same time, in real government function, we have to have some mechanism for dealing with the unforeseen. And the bridge contract is one of those ways, and it's a very useful and effective way. Currently, we're doing it through emergency procurements. And so which would we rather have, the bridge or emergencies? We're not always dealing with it through emergency, but many times. And maybe emergency shouldn't be the default. The bridge maybe should be the default for those. And we do want it, carefully crafted, but we view the bridge contract as a good thing.
Yeah, I know you weren't here the last meeting, but first of all, looking at what the default is when your contract expires or the other person can't come online, I think they use small purchase more often than the emergency procurement. And what I was saying about the last hearing that we held is we agreed, or I think there was consensus, to increase the small purchase price. I think, was it, I forget.
From 15 to 30.
Yeah, to 30. So there's your avenue. So that does provide a little bit more of a cushion using small purchase, which I believe is more common than the emergency procurement for these types of situations that the bridge contract would otherwise be applied to. So I think the cushion is there.
I think the bridge contract only applied to things over 200,000 as it was originally drafted.
There was that.
It was only for big contracts.
There was
so the
that,
small
but
purchases will not cover that.
But we're also, I think, primarily looking at the bridge contract to keep the services of the incumbent in place until the new contractor comes in. If it's, if everybody feels comfortable enough, I only took it out because of the fact that there was not enough consensus
At that time.
that,
I know it's to keep the incumbent, but I think
I think a good example, I'm sorry.
Go ahead. I was going to say the majority of the procurement appeals that concern these small purchases are the incumbent receiving it during a period where there's some transition going on.
Yeah. I think a good example was with DOE on the telecommunications part, right?
There you go.
Huh?
That's still making its way to the courts.
As well as copying, the copying machine.
Yeah.
Yeah. Food services is, yeah. All of these types of extensions always favor the incumbent.
Well, yeah, but the bottom line at the end of the day is the customer's got to be serviced.
Yes, yeah, I agree so much.
Yeah,
Yes.
it's got to feed the kids. I have no problem. I mean, I can just go back.
That'll be another day's discussion.
And I think
Bookmark.
I think how it
Another
was.
day's discussion.
At least, as long as we keep it to the same group.
Yes, okay. Look at revisiting. Man, we've had a lot of bookmarks today so far.
Oh, is that because I'm back? I'm sorry.
Okay. All right. So I'll bookmark and we'll say for another Roundtable, then take a look at the bridge contracts. Section 13 of the bill, responsibility of bidders and offerers, and it's just, I think we put in there language to the effect that that the determination shall be made and served on those bidders or offerers before an award can be made. Let's see, what was the concern there? I think Jessica had asked if this prerequisite also applies to the issuance of a notice of intent to award. And
So
before an award can be made. So
Yeah.
then
Notice of
before a
intent.
notice of intent to award,
notice of intent to award, as pointed out by John Thomas Brown, is not like, it's not a statutorily
right?
used language. It's more of a, it's basically just how it's been termed, because under 5216E we have to issue a written notice of award. But for the government's purposes, we don't consider the actual award as awarded until the contract is signed. So that's the award. The award is the contract. So under 5216E, we have to issue this thing that tells this person they're getting the contract, but they're not awarded the contract until the contract is signed.
Yeah, I think the purpose of the notice of intent
Yeah, we
to
call it
award
that. Yeah.
is just to let
It's
they just let them know, especially in construction contracts, so that the contractor can go start getting the permits, and sometimes that's a very lengthy process. And if you start the clock on the contract itself, the clock to construct, they could lose whatever months that it took to mobilize and bring in the permits. So they give you this notice of intent to award, and you go start mobilizing,
Yes.
doing all your things, and then as soon as we sign the contract, that pushes the trigger, and you are now on a timeline to finish building that bridge, that road, or whatever. And if you don't finish it on time, liquidated damages start to creep in.
Yes.
So it really is just more of a timing thing.
Yeah.
And but Jessica's right. The notice of it. I think there's an AG opinion actually on this, that notice of intent to award is not an award
Yes.
So that does not
Yes.
start the 14-day clock
for.
for purposes of. So if you put out a notice that you were gonna, I intend to award him the contract, that does not start my 14-day clock to go and for my protest filing.
That's
That's a good question.
Yeah, no,
I
that's
think it's always-
received. Now,
that's always-
theoretically, that would
Yeah.
be true, because you can say that, the protester either
It
knew or
does.
should have known, and I think some savvy agencies have tried that, but when it gets to the court level, there are different interpretations of that. So some courts would say, well, the notice of intent toward it's not the actual award, and the procurement protest statute actually says that you can protest an actual award. So the notice of intent to award, the other way some of these judges have interpreted it is, although there's a notice of intent to award, they don't know if the person will actually be awarded.
Right.
It's just an intent.
They-
So once the award comes out, that's typically when they have literally a second bite at the apple if they don't file the protest when the intent comes out.
Well, I guess
Yes.
that works to the advantage of the losing bidders.
Yeah,
Because
so
they'll have
when-
more time to.
So when we say before an award can be made, it's really kind of crucial that we pin it down. Is it going to be the award, or is it going to be the determination under 5216E? We can definitely change that to, it shall be served on such bidder or offerer before the notice required under 5216E, which is called award.
Yeah, and it is an award. I don't see notice of intent to award in 521.
It's not called, and that's what we call it because
That's
it's
what you call
really
it, right.
not the
Okay.
award.
Yeah.
We're required to issue a written determination of award saying we intend to award you this contract, but it's not considered awarded until you actually have the signed contract and it's effective and signed by the governor. So we do have these two
So
kind of award.
So are you saying that in
related
line
dates.
6, we should add qualifying language before an award pursuant to section 5,
That
whatever?
only applies to RFPs. That section only applies to RFPs. It doesn't apply to IFPs or FCPs.
Okay.
So if you did that, you'd be eliminating the rest of it. Before an award or notice of intent to award can be made? Do you want to do it that way?
Well, we don't really love that language either.
Yeah,
Notice
yeah,
of intent
so
to award. We don't like that, but we should pin down what that date is. Is it
I don't
is
know
it the
that
date
we
of the
can.
written notice,
I don't know if
or
we
is
can.
it the date of the
The award
contract?
is just,
Is it the date of the signed contract? We'd be happy with that.
Yeah, it's the date of the signed contract, and you can probably define it. And there is a statute that says, a contract is not a contract on 5 GCA section 22601.
That's until the governor signs
All
it.
contracts of whatever nature shall be executed upon the approval of the governor. So that means you don't have a deal, you don't have a
You don't have a
contract until he signs it.
Yep.
22601. So maybe you can
yeah.
refer
I think if you
to
took
that.
award out of the whole statute and just replaced it with contract,
Okay.
you would have an awful lot more certainty.
That would work.
Yeah.
Well, my understanding of this particular section, we're talking about section 13, right? Okay,
Yes.
okay, I know that it has that language, but it's really a determination of non-responsibility. That's when you're telling somebody, it's not that we reject your bid essentially because we don't think you can pull this off. Or we don't think you can do the job. You can't, you don't have the infrastructure capability to do it. This, as I read this language, it just says you have to make this determination before the award can be made
Yeah.
of non-responsibility. That's all it is. They're very rare. I can only think of 3 instances where I've actually seen this done in a solicitation. So I think in terms of A, where it says before an award can be made, I think that language can stay the same, but Jessica's right. I think we might want to revisit where it says in the regular solicitation statutes when awards are made for that. But I don't think we need to specify award here because it's limited to determinations of non-responsibility.
Yeah, I guess I think it's because we consider the award as made when the governor signs it, right? So for the purposes of this, I would read this as saying a written determination of non-responsibility of any bidder or offer shall be made and served before the governor signs the contract. So that means, it's just kind of any time before the governor signs a contract with someone else.
But not everything is a contract, purchase order. It's a purchase order. Purchase order is a contract.
Yeah.
The
Yeah,
governor
he doesn't sign that.
the PO. So the agreement between the
Turn on
vendor,
mic, turn on mic.
the agreement between the vendor and the agency can just be a purchase order itself, and the governor doesn't sign the PO.
Purchase order for you
That's
can
the
only
binding
use
contract between the vendor and the government
supplies.
agency for supplies.
for
And the only
under
time we
certain
require a
amounts, right?
contract would be for construction under IFBs for the bidder. Over 50,000
over 50,000.
for construction.
So that makes
Because otherwise it's a small purchase.
So-
Yes, sir.
And now we've raised it to 100,000.
right. So that makes this So that makes figuring out when you have to serve this document even more complicated because of this language.
When it's a formal solicitation, we do issue the letter of intent.
No, so this new language says, that's what we're trying to figure out is when do you have to serve this letter? So if you do it by purchase order, when is that? When is the award made? Is it made when you sign it? So then you have to serve your letter before you sign this purchase order. Right? That's what we're trying to figure out. When do you have to serve these letters of non-responsibility? And if it's different for purchase orders and for contracts, then you have this. It's tough to figure out when is the award, especially if it's different for purchase orders and contracts. We're trying to make it easy for agencies to figure out when they have to serve this.
Anthony?
Yeah, I was going to say, award, I don't really see that as being very problematic. For example, in a procurement appeal, it's very easy to determine, that's one of the first questions we ask is this post-award or pre-award? Because that determines what your remedies are. And the demarcation line usually is a purchase order or the contract being executed. I think that's a fairly bright line, so I don't see any problem with the language of award here for issuing this determination of non-responsibility. I do have a little problem, though, just with the language served.
The service.
Were you actually, John, was the intent here that I hire a process server and I have it personally served on the head in accordance with...
No. It was just to give notice to them that,
but
they've been determined to be non-responsible.
That's fine. I think if we replace serve with given notice or something like that, the reason being is the way the court would interpret that is,
Right.
where's your process server? No
Given notice.
process server that's...
Given notice, okay.
Okay. And the only other thing I want to add is online, where it goes just a little 4 lines down where it says dissimilar solicitation. That's the other question. John, when you say dissimilar, does the other solicitation, it can't be for the same type of service or supply, or did you just mean other solicitation?
It was meant to avoid the implication that if you're non-responsible for this solicitation, you're just a non-responsible bidder and you can't bid on any other thing. But you may be non-responsible because you're a doctor but not a surgeon applying for a surgeon's solicitation. That doesn't mean you're a non-responsible person. If they come back and they're soliciting for other medical services that don't require surgeon specialization, you wouldn't necessarily be non-responsible. So that's the dissimilarity aspect of it.
I was just saying, you could use the word other, or it doesn't matter to me, but one way or the other. I think if you say other solicitation, I think that's a little more concrete and specific, and it's a little broader. But
if it's the same kind of solicitation, though, I mean, if it's exactly the same solicitation, I would think that they would be non-responsible if they were a non-responsible one. The whole idea of the non-responsibility is the agency should be sharing that knowledge of who is and who is not a responsible bidder, so that they don't have to discover something that's already been discovered by the government. That's the whole reason. That's the difference between dissimilar and other. But however you guys can word that, that's the idea. Being non-responsible in one case doesn't mean you're non-responsible for all other cases.
Okay, but the problem is the word dissimilar is somewhat limiting. So the way I look at that is, all right, so if I have, I'm non-responsible for delivering number 2 pencils, essentially for one solicitation. Does that mean that I'm disqualified for the next solicitation for number 2 pencils? That's because here it would have to be dissimilar. You follow me?
Yeah.
And I agree that there may be situations in terms of licensing. That's usually where this issue comes up. You don't have the appropriate license to do the service. or what have you. You lost your license that you had before you issued the solicitation or whatever it was. So in terms of a license, you need to be a lawyer if somebody gets disbarred, for example, and they can't do it. They're non-responsible. That's where we apply, but in the pencil scenario, it might not. You follow me? That's where I think other is broader language and less limiting. But
And in the meantime, I agree, other is better, because in the meantime, they could have become responsible. Because you can always become responsible. You could always, if you have a disbarred attorney or they're just suspended and then they get their license back.
I'll accept other.
So other.
Okay. Okay. Anything further on section 13? Section 14, potential contractor lists. Let's see. You had suggested that, Anthony had suggested that the prospective offerers on the list be vetted and considered as responsible offerers for the purpose that list is made for. John Brown disagrees that those who get on the list should be considered responsible. OPA asks who puts the list together, and those were the three questions that were raised. Any discussion on that?
The whole point of the pre-qualification suppliers is to make sure that they are qualified to provide a service or a product. It goes more to responsiveness than responsibility to that extent. But to the extent it does go to responsibility, if you determine that they're responsible because they're on this list, tomorrow they may not be responsible. And so you're going to have to make that determination of responsibility come the next solicitation anyway. You haven't saved yourself any time. And what you're doing is you're having to make sure that every person who is even just a prospective bidder is responsible. So that's an awful lot of responsibility determinations that you have to make, which may come to naught if they don't bid or if their circumstances change. So I just think it's not an exercise worth doing.
I remember there was some agencies, those who require like engineering services and whatnot, I guess they call it they create a short list so that we know that we're going to be needing mechanical engineering services. So they put out this solicitation, and all the mechanical engineers who think they are qualified mechanical engineers will then submit their names, and the agency creates then this list. And when it comes time to solicit for mechanical engineering services, they send it out to the people on this list, and as well as but it's kind of like gives them a running start, I guess.
Yeah. But the federal government does that in the context of multiple awards, where they get a number of people who bid on a contract that they're going to end up getting a task order or not getting a task order. So in that case, they're a bidder. They're determined to be okay to do this job, and they're just waiting to see if they get a task order. So that's a slightly different case than here. You're talking about prospective people who you don't even know for sure they're going to bid.
Well, I know that I think the example I used when we first discussed this was this is more or less for the bigger contracts. I know that the only potential bidder list that we used, or I've seen used a lot, were I was GPA's attorney. We had a short list for oil suppliers for fuel for the baseload generators because there were just very few people that could do that. Now, they were still open. Yeah, we sent them the RFP when it went out, or not RFP, IFP. But even then, they were still open to anybody who wanted to submit a bid. But we wanted to make sure that the few 3 or 4 entities that did business here had notice of our RFP. So that's why we use that list. But there is, I think that there should be at least a presumption of responsibility, generally speaking, if you're on the list. That's what it should mean. But you know, if you're saying that you are, John is correct that, you know, in the solicitation itself, you'd still had to make that responsibility determination irregardless every time you do the procurement, even if they're on the list. But I think that there should, at least if you're on the list, you should be presumed you're responsible.
So I guess what we're debating here is the on line 6 on page 27 of my paper here. Inclusion of a potential contractor on any such list of potential contractors does not determine responsibility in and of itself, nor shall any bidder or offer be rejected for failure to be included, nor shall public notice be limited to those who have been included.
Yeah, I don't really have any problems with that particular
okay.
language. That's okay.
All right, so we're fine with section 14.
Yeah.
Okay. We'll go on section 15, cost or pricing data. And on that one, we really did not have, there was no concerns raised in previous discussions. Section 16, there was concerns raised on page 29 of my under paragraph C, disclosure of ownership. There was concern about the phrase "as a condition of bidding." The AG's office and Anthony suggested this phrase to provide to provide a bright line rule for the courts. Disagreement was that requiring disclosure statements now makes this submittal a matter of responsiveness. That's John's objection.
Well, since the, goodness, I want to say, since the late 90s, the courts have consistently held that this language means that if you have, or if you don't have, your disclosure of ownership, or basically your major shareholder's affidavit, essentially, your bid is automatically non-responsive. And I tend to like the language because what it got rid of was, or what was happening, the purpose for this long ago was people were, I guess, forming companies or corporations, and these are people who were in agencies that were soliciting for these services. These were multi-million-dollar contracts, or their wives or their spouses or children were in these corporations. So that's really the purpose behind the law is, okay, disclose who your major shareholders are, so essentially we avoid these types of conflicts of interest or self-dealing even in our procurement. And I think we should continue that policy by requiring them or bidders to disclose their major shareholders, as we've done for decades now.
Yes.
I don't think that it's not that I'm not opposed to this, don't get me wrong. It's just that where I always see the issue is like the mobiles and the Xeroxes of the world, because, and I always forget now how they disclose it, for publicly traded companies is where I meant, because for publicly traded companies, 10% or that number can change, and you have to go almost to the disclosure statement, I think it is, right? The disclosure statement that went out with the proxy in order to find out who is the 10% or more. So it's just more in those instances where in publicly traded companies, it can be evolving.
In response to Anthony's statement about this is required. We need to know who we're doing business with. Totally agree with that. This doesn't say otherwise. That's what the inquiry into responsibility is all about. Who are we doing business with? Is this capable? Who owns this? Who's this person? And so the real question comes down to when do you make this effective? We're used to determining responsibility after bid opening before award. That's what the whole law is all about, a determination of responsibility. Disclosure is who. That's a primary factor of responsibility. Who are we dealing with? Is this person with integrity and a record of performance and those other matters that make us want to do business with them or not do business with them if they're non-responsible? So it's not that taking this language out as a condition of bidding is going to say that there's no longer any disclosure requirement. In fact, this provision really ramps up the disclosure requirement by making you peel back those layers of ownership that are done by these Phoenix corporations that just have a new name, same people. So I think what we do by saying as a condition of bidding, you give the impression that you're non-responsive if you don't have this information in the bid package. And a bid can be open for weeks, months before it's finally awarded. And during that time, companies change. They change owners. Our disclosure requirement requires that they give that information as of the bid award. That's when it's really important. When you're going to award the contract, you want to make sure you know who it is that you're going to get the contract with. And if you kick them out right away, the information that they provided was right at the time they gave it, but it's wrong by the time you get the award. What good have you done? You haven't gotten the most competition out of that party. I think we saw with the GTA contract that GTA had a better price, but they were thrown out because there was an error. There was a change in the ownership that the guys filling out the form weren't aware of. So we just threw them out. But we could have determined later, and we could have cured that incorrect information later before the award, just like you can with any other issue having to do with responsibility. That's the whole point here. It's not that a disclosure is unimportant. It is eminently important. You can't award a contract unless it's a responsive and responsible party. But those two things are determined at different times and by different standards. And also condition is ambivalent as a condition of bidding. Well, first of all, this doesn't apply to just bidding. It's meant to apply also to proposals. And particularly going to want it with the sealed comparative proposal process. So bidding is the wrong word. Condition, what kind of condition? There are conditions precedent, conditions concurrent, conditions subsequent. Responsiveness is a condition concurrent. You determine at the time you open the bids. Responsibility is a condition subsequent. You determine after the opening of bids before the award. So I don't think that this language is as clear and meaningful as is implied, and I think it misses the point that it does not do away with disclosure. It allows you to take people who want to compete and who have changes in ownership or errors in ownership that aren't important until you decide that there's a prospective contractor who's going to get the award, and you have to make that determination of responsibility. That's my objection to it.
I think that raises my point, which is it's not just who, but when. There is a real time factor to when you make the disclosure. And the government needs to know it as close to the time of award as possible. Government needs to have the best information when they make the award. And I had previously raised this issue that this new C, now we're making, now it says as a condition of bidding, which we agree with, but it still says immediately preceding the date the solicitation was issued. Which means we issue the solicitation, and if we give bidders 4 months to get their packages together, they only have to disclose everything in the 12 months preceding the date of the solicitation, not the date they submit their bid. This is very problematic language.
So are we looking at changing that?
I previously
That date?
requested it. Yes.
I don't think there was a strong opposition there.
No, and it's not changed. It still says the
Okay.
date of the solicitation, which would be the date you issued your
Proceeding okay, so we want to read then during the 12-month period immediately preceding the date.
that the bid or offer was submitted, is submitted.
That the what? Oh, that the
Bid
bid
or
was,
offer
that the bid
is
was submitted.
submitted.
It says immediately preceding submission of a bid.
Yes, and we need to keep
So
that.
I think we just need to
Yes. Yes, the original language, because this allows for a gap.
And we're allowing it also for offers, right?
Yeah.
Yes.
Yeah.
Okay, so it should say, we
Bid or
change the
offer.
original language.
I think that condition of bidding is just long on so many counts, it just needs to come out.
Okay, yeah, I would agree. I think this shouldn't just apply to bids.
Well, the consequence of taking out the language as a condition of bidding, or as a condition of whatever, you can change the word bidding if you don't like it, but the consequence is that, so if I fail to disclose my shareholders, then you can't kick my bid out at all. That's an informality to which I should be allowed to amend, all right? And here, though, disclosing the major shareholder, and this was really, like I said, the reason it's in there, the reason why the language was so strong and the effect was so great was literally to prevent what was going on before from happening again. These are people who become agency heads, and they're only making $30,000, $40,000 a year back then in the 80s, and they walk away and they're millionaires, okay, because they're literally dealing themselves or giving themselves lucrative contracts,
Yes.
and that's a complete abuse of authority. So that's why this language was so strong initially. Now, if you don't like I said, I still like the word as a condition of bidding. That way, if you don't disclose your shareholders, or as a condition of participating in the solicitation or what have you, if you don't disclose your shareholders, yeah, you're non-responsive. You're automatically pitched. You shouldn't be allowed, oh, we caught you, oh, okay, I'll just change
I'll just
that,
fix
because what they might be doing there is the solicitation goes out, oh, we need to get rid of shareholders A through Z and put straw people in their place, so we still get, you follow me? That's the kind of games that you'll see played.
And I'm sorry. And I think that making sure that we changed it back to bid is submitted, data goes with as a condition of bidding. It makes it clear, when you submit your bid, your information must be accurate and included as of that date, so that the government can make a determination there. And because you're gonna have agencies, if you allow, so we have this lovely bright line of the date of the submission of the bid, and then really the agencies don't accept anything after that. Anything. You can't change your bid unless the agency asks you a question, and you still can't change it. You can't change it, but you can. The only time you can supply anything after the bid submission date is if the agency requests it. This kind of idea that you could just keep sending the agency updated information after the bid date creates kind of a very confusing situation for lay people in agencies who are just trying to handle this process. The bid submission date is a drop dead date, and we don't take anything after that. Then we don't have problems with other bidders saying, well, they changed their bid, they gave another disclosure statement, and they now now disclose that this person is a new owner, and they're friends with so and so, or it's just, bid submission date is such a nice date for the agencies to handle.
I think as a condition of bidding language would satisfy me and perhaps you folks if it's at a condition of award. Because that's what it is. I mean, if what we've heard right now is accurate, it's a drop-dead date line when the bid is submitted. You can have no change in the information you've provided about your ownership. And we're talking about off-island bidders who are typically large and publicly traded companies who has a fluid every day. Their ownership is changing on the stock market or in some other market. And you have to be able to update that. That's what the whole process of this inquiry into responsibility is about. That the agency has to receive information, ask for information about responsibility all up to the very last moment before you award the contract. That's how that process goes. And that's what we're dealing with here is responsibility, not the bid. Not the bid. You're not changing the bid. The bid is just saying, I agree to give the government exactly what they want. They're not asking that I'm who I am. That's important to them because that determines responsibility, but you don't give that information. You're not required to give that information at bid opening. It's just overly bearing. It's bloody-minded. Just let's have a firm date, a drop-dead date, and that's all got to be in there. Otherwise, we're not even going to consider your bid and the competition that you bring to the table. I think that's foolhardy. Might as well not take responsibility out of the code. Just says that as long as your bid is responsive, you're good enough for us.
So now you're suggesting a change in the wording instead of as a condition of bidding, as a condition of award.
Yes.
That, and then on who the owners are, that it is to be the owners at any time during the 12-month period immediately preceding the submission of a bid.
Yes.
I think you're spending a lot of time, John, worrying about these big companies like Mobile, and they're fairly sophisticated, and they could tell you at any hour, their procurement personnel, who owns the company or owns more of a certain percent. So it's not, in the digital age, as difficult as you might think, or as onerous for them to submit a bid. And then what will happen is, and remember, we're not trying to catch the big companies. Like I said, the real purpose here is to try to catch self-dealing, dealing with close family members, basically ethical types of violations. So if you make this a condition of award, what's going to happen is they would have to, you could require it, I guess, at the time you issue the solicitation, they'd rank the highest or whatever, or the lowest price, and you go all the way to the point where you get to award, and it's like, oh, I didn't know that your spouse works for us, and we can't award you that. But you've gone through the whole process versus you didn't make that disclosure up front, your bid's non-responsive, and it doesn't go to responsibility, it goes to responsiveness. It's just a document, it's just a shareholder affidavit. That's really what it is.
The shareholder affidavit determines who the parties you're dealing with is. That is a question of responsibility. The bid provides the specifications, and that's it. The specifications of the product.
Doris?
I beg to differ. I think we need to know both times. We need to know at the time of the bid submission who are the bidders. I mean, that is a condition of responsiveness. Okay, I want to know when I open my bid, who am I dealing with? Okay, both from the buyer as well as from the OPA, if we turn on the hat. I agree with him that responsibility comes afterwards and ownership, but at the time of the bid, GovGuam should know when we open the bid, who at this time we are dealing with. And I think that's important at that time to know. And that is responsiveness. So this is kind of like where we are now splitting the hairs. We are splitting hairs. So, and we have seen the situation where responsive, the lack of of filling that out has been wrong. I look at it this way: hey, you're a big boy. If you don't know how to fill out the form, that's tough luck. Sorry, out of your, you know. But GovGuam should know at the time we open the bid, responsiveness, who are we dealing with? It might require later on the final determination of responsibility, but we need to know at the time we open the bid who we are dealing with.
You will have their name, rank, and serial number on the bid form as to who you're dealing with. Unless they're the lowest bidder, they're not going to be even the prospective contractor. If you've made the statement that you have to have this or we're not going to consider your bid. So it doesn't matter who they are at the time of the award, you're not going to consider them anyway. And that just doesn't make sense to me.
I don't know, John. It goes, okay, if a corporation submits a bid, that's all it's going to say, XYZ Corporation.
Yes.
And then they might identify one particular point of contact who acts on behalf of the corporation, but then again, it begs the question, well, who owns this corporation? And that's where the shareholders affidavit comes in. This is something we've used for a very long time, and we really haven't had much problems with it. Hence, it's more of a bright line. I don't see why making it murky is going to fulfill the policy by putting it towards the end or making it possible for bidders to amend shareholders' affidavit if they don't get it right the first time. I mean,
we
I
put
don't
some
see
very
what that-
important things towards the end. We put capability to perform towards the end. I think capability to perform is probably more important than who you are. They're at least equally important. What's important at the front is, are you giving us what we want so that we can go through the evaluation process? That's responsibility. That's responsiveness. Responsibility is, are we going to do business with you? We got to know a little bit more about you. If you provide information that's accurate at bid opening about ownership, what's the effect of a change in ownership before the award is made? If that's a week or 2 weeks or 2 months or 6 months later, what's the effect of that change of ownership? It makes the original disclosure signed under penalty of perjury wrong.
Well, it goes.
So you really want to do it at a time of award, not at the time you open the bids.
Logically, I disagree with you there. I think that when you open the bid and they don't have the shareholders affidavit out, or if it's supposed to be 12 months before the bid and they're using the one they used last year, and it's dated last year, you're out too. That's it.
Not having it is maybe important, but what about the changes that are made? I mean, you have a OPA decision that says that GCC did a responsibility exam when someone had a change of ownership and they cured the notice, but you said, no, they can't do that. They can't cure the notice. If there's been a change, you can't change it. It's just dead in the water, to use the language over there. So I think that if you're going to be keyed in on a condition of bidding, if you don't have this information accurately in the disclosure statement, because it is signed under penalty of perjury, you're eliminating a lot of people who will have changes in ownership and people who made a mistake in ownership. They're owned by somebody overseas, and the person overseas that authorizes them to bid here didn't get the word to them that they've changed it. If they've changed it tomorrow, they can't cure that. Things that have to be in the bid package are uncurable if it's a matter of responsiveness. You cannot change your price after the bid's open. You can't change your specifications in any material way after the bid's open. But who you are, what your capability is, what your financial arrangements, personnel, all of that can be fixed all the way up to opening. up to award. This is no different from that. And
Well, I think we already sufficiently make a time for this. If you say, okay, you have to disclose it 12 months before bid or offer submittal. I think that's
12 months before the bid, you have to disclose your ownership?
well, the deadline to submit your bid or your offer, or your proposal. I think that's a pretty good line. I know that the statute says the solicitation is issued. I don't mind that either, but I think you want to get it closer to award than the deadline to submit the bid or the proposal is where you could change it to. But I disagree with, like I said, allowing them to change it before the award, or you'd have to spend more info. I think at the very beginning, it's important to disclose if you're a corporation or any company who your owners are. Because the purpose isn't just, you're treating it like, okay, that's who we are, but really the purpose is to make sure that an ethical violation is not being made. That's really it. And it's, you have to add teeth to that, because this is something that a lot of companies, if they're planning that, they don't want to. They might resist such disclosure. They might play around with it. Here, this makes it harder for them to do so.
I agree. I think who you are is distinguished from your ability or your responsibility and your ability to perform the contract, in that who you are goes to ethical questions. Your ability to perform the contract isn't an ethical question. Who you are is, and that's why they're different.
Doris?
No, just maybe to answer John's concern, rather than the date the solicitation was issued, change it to the deadline for submission of the solicitation, because the solicitation date could be 3 to 4 months out before, depending on the nature.
Well, we've already changed it to immediately preceding the submission of a bid.
Oh,
Yes,
okay.
yes.
Yeah.
Okay. Oh, okay. That must have been when I stepped out. Thank you.
All right, so I think we resolved that part. The only part that hasn't been resolved is, do we make the disclosure a condition of bidding or as a condition of award?
You have two schools of thought here. You have to be Solomon to decide.
And
He's got a point.
I have a suggestion in that
You have two conflicting schools of thought. Okay? You have to be Solomon and decide.
I think you can resolve this by saying that as a condition of bidding, you must disclose you must have this disclosure in your bid. And then you can say somewhere in here, however, if you have a change of ownership, you can amend the disclosure anytime before award.
That sounds good.
But if you don't have it in, the whole purpose of the as a condition of bidding is really to prevent,
To know who we're dealing
to know who you're dealing with when you open it up, and if they don't tell you up front when you open it who they are, and then they seek to kind of backdoor it in, that defeats the purpose.
I
But
think
you could allow an amendment if ownership changes before award.
I think you're onto something there. If you can say that you supply it with your bid package, but it is curable, it is changeable if there's any change in ownership subsequent to the original submission.
upon award.
Yeah,
Prior to award.
up to a time of award. It just cannot be absolute. Nothing else in responsibility is.
Because the government would want to know. So if it's if there's a bid, and we don't love the idea of allowing amendments after a bid is submitted, but at the same time, because it's an ethical question, you could have a bidder submit their disclosure. It's correct at the time they submit their bid, and afterwards change ownership, and now you have an ethical conflict, and the government would need to know about that.
Okay.
Yeah, I wouldn't object to that type of a change, but you'd have to put additional language. Okay, basically it would say that, all right, so you could, you have to have it at the time you submit your bid. You can have a change of ownership if one occurs after, the deadline to submit your bid, but with the exception of any bid that would initially create an ethical violation.
Correct.
Here's the scenario that this
Yes.
is really, it goes back to the word condition. So let's say that I'm the head of, let's say I'm the GM for GPA. And my wife, I put her at the head of a company. And I make her, okay, you have 75% ownership of this company, wife. And I know that we're going to submit the bid. I'm creating it just for this solicitation. And she submits the bid, obviously ethical violation right there. She gets caught. Hey, you're Camacho's wife. We'll just change the ownership. You follow me? So by putting
You've
that,
only made her a GM. You haven't changed her ownership, and this only requires
no.
ownership
I'm saying
changes.
I'm saying if she was the major shareholder.
Oh.
Okay, I'm just using this as a hypothetical. And I shouldn't be allowed, if I already get caught trying to make an ethical violation, I shouldn't be allowed to just correct it, and by switching owners is what I'm trying to say after I submit my bid.
Right.
So that's really what the purpose of this. Now, if I'm mobile and some institutional investor, through public trading gets another 10% interest, and before the award I say, look, here's my change. That's a different story. That didn't create an ethical violation to begin with, so that change could be made. But so I think that with that additional language, you can change, or if your bidders change, you have to change it or update it, whatever, if you're going to get awarded,
Yes.
with the exception of an ownership interest that would have constitution or is an ethical violation at the time the bid submitted.
If any of your disclosure affidavits revealed a conflict, then you would be out. You couldn't just, and this, I absolutely agree. They should be, the government should have the most updated information when it makes the award, but you should not be able to amend to erase a conflict that existed in your original disclosure. So you have to make it very specific that in the event of a change in ownership, you can submit an amended disclosure affidavit. However, if you have any ethical conflicts in any of the disclosure affidavits you submitted,
I'm a little bit.
you're going to be disqualified.
I want to take a little bit of issue with that. To this point that you made that you can't solve an ethical violation at the time you submitted your information by curing that, by putting somebody else in, taking the ethical violator out of that process and putting it in later. Because the ethic violations only apply to actually have an actual conflict of interest, which is a contract, or being involved in the review of the process. If you take that person out, they're no longer part of they're no longer an ethical violation.
Are they?
Actually,
If their initial disclosure showed an ethical violation, they're required to give you, as a condition of bidding, their disclosure affidavit, and it clearly showed a conflict.
it's tantamount to being caught in the act, and you shouldn't be allowed to cure it, because odds are you're not going to cure it with someone who's entirely disinterested.
Well,
You're
you
going to say,
might find
okay,
that person
I'll take.
non-responsible then, because they
It
are.
doesn't have to do with responsibility at all. I know we disagree here, but this has to do with responsiveness, because I would look at such a change, and I think the general public would, with great skepticism. I'm going to replace, let's say it's my wife, and she steps down and gives her shares to her good friend. Is that person really disinterested?
Yeah, I would find that person non-responsible. You don't have to find them non-responsive. You can find them non-responsible and throw it out. I'm not saying that
I don't see how, if the corporation, for example, can perform the contract in all respects, that they would still be responsible, but they wouldn't be responsive.
No, they don't have integrity. They came into this with an ethical violation.
But again, that's where we said we
Okay.
have
Two schools of thought.
Okay.
All right.
Let's
So
move on.
I've
Let's
duly,
move on.
Thank you.
Solomon, you can decide.
I've duly marked it, and we'll come back and revisit that.
Solomon will
Okay.
have to decide.
All right. So moving on, is there anything else on page 30? Page 31, there was I guess there was suggested that we add on the every disclosure of ownership required to be identified with shall name the person required to be disclosed, the mailing address and street address of the residence, and a taxpayer identification number shall be provided. In the case of an artificial person, a taxpayer identification number shall be provided.
But is that,
Yeah, you were asking whether that was subject to privacy requirements as the Social Security. And
Yeah, I wouldn't want I don't think most business owners would want their EINs floating around out there. I know that they have to give those to agencies, but nevertheless, that's something that could be used to make fraudulent documents, to do things like get tax returns,
Yes.
for example.
yeah, I think I would delete
All right.
that just in this day and age of privacy.
so we're going to delete taxpayer.
Identification.
We're going to delete then of residence or principal place
No,
of
no.
business, period.
No,
Yeah,
only
yeah,
tax.
after period after business.
Yeah. And then, so we raise, in the case of artificial
Yeah.
person, the TIN shall be provided.
Yeah.
We'll delete that.
Yeah.
Okay. And then, okay, so that's the old language there that were all crossed out. Section 17, types of contracts, section 5235. Let's see, so I was concerned that the contract is, say, for 5 years, but on the 4th year, a second item for another need for 5 years. Oh, there's the question of the supplies by lease on the indefinite quantity contract shall not be used to acquire supplies by lease if acquisition would extend performance of the contract beyond the term of the contract. So the example that John had used was, this is a 5-year contract, and on the 4th year we buy another lease, which would extend that lease out 5 years, as opposed to that second lease being only good for up to the 5th year, the original 5th year. Okay, any questions with that?
I have,
Terminates it.
when we say supplies, what kind of supplies? Just, is it movable supplies? Is it,
Supplies by definition are expendable.
yeah, expendable?
The supplies are defined in the procurement law, so those kind of supplies. 50, 30.
How could you lease it?
It would seem that it would be services by lease as opposed to supplies by
You never
lease.
lease services.
Yeah.
You
it would
always
be
lease
equipment.
supplies.
That's,
Or is it equipment that you?
yes.
Well,
Yes.
I was thinking,
Well, in the definition of the law, supplies means consumables as well as equipment. It means anything that's a tangible product, basically. 5030S, I think it is. Yeah.
Which is not necessarily.
I was thinking of services from the standpoint of, let's say, vehicles.
No, services means furnishing labor, time, or effort. Supplies means all property, including but not limited to equipment, materials, printing, stationery.
All right.
Okay, so
That's
it's
broad.
defined in there.
Yeah, okay.
But it says all property, right?
Yes,
All property.
all property.
Yeah, so, it's not just expendables, right?
Not just consumables.
Expendables.
What was that? Where's the
Right.
definition of supplies?
5030S. I'm sorry, that's services, 5030U.
So, I mean, so I'm just thinking of things that are near and dear to my heart. When we say supplies, all property to me kind of includes real property. And like, but it does it.
But this is defined to indefinite quantity, so,
Yeah.
yeah,
Yeah,
yeah.
Yeah,
So
so-
not everything is an indefinite quantity.
right.
I can
Yeah,
see
the-
for.
Land would not be an indefinite quantity, for
Would be
example.
indefinite.
Okay, any further discussion on the supplies by lease? Okay, we go down to section 18, multi-year contracts. And the question was, it is the policy of the government of Guam to minimize the use of multi-year contracts and to require that the terms of all contracts be for only such minimal term as is practicable. And of course, 37.
But section.
Need to close the debate on whether to minimize multi-year contracts or... yeah, I guess the argument was to get the best price, you probably want to give it the max time limit.
So I remember this a little differently, and I have it in my notes as, I said we really shouldn't be making any broad policy statements in a statute. Don't need to make a policy statement here. It should just, no contract shall be issued. There is no reason for this policy statement, particularly because it shouldn't be the policy of the government to have the shortest term contracts possible. It should be the policy to have to represent the best interests of the government. The way I remember it is that everybody said, "Oh yeah, that is our job in procuring supplies and services is to do what is in the best interests of the government, not to have the shortest contracts possible." And everyone agreed, and I remember I thought it was said on the record that we would just remove those lines.
So to leave the yellow.
Mm-hmm. I thought I saw general assent, and that there's really no reason to make this policy statement.
Okay, further discussions?
Well, I thought we resolved it by saying there was a presumption of a 5-year limit. That's
Yeah.
on the next stage. But
Yeah, and that we were just going to take out that policy language, and there's no need to state that.
Lines
because-
15 through 17.
Because it really does not accurately reflect the government should not be our stated policy that we are going to have the shortest contracts all the time.
Okay.
We are going to do what is in the best interest of the government.
Okay.
That requires a longer term contract to get the best price, then that's what we're doing.
Okay,
I-
all right. So there's no further discussion?
Yeah, we just...
We'll
yeah.
just delete those 3 lines.
Yeah.
Okay. Okay. Go page 33, presumption of 5-year limit. Concerned about the max time limit. That was a concern raised by the AG's office. Okay, any discussion there?
yeah, I think this, although there's a presumption of a 5-year limit, this does have the mechanism to extend or create a contract in excess of 5 years as well towards the end.
I have to say that I like this section. I think this presumption of 5 years, this is just writing down what has been an unofficial unwritten policy in the government for a long, long time. And I've always heard flack, well, where are you guys getting this 5 years? Where does it say that it can only be 5 years? But we've actually been doing this. And to the extent that it is written down, I've seen it in letters from the AG disapproving contracts over 5. And sometimes, we've made it 6, and it just depends. And so it's good that there's some flexibility. But I think the original reason why that 5 years was put in was because prices do change. And sometimes when you go out to bid, 5 years from now, you might get a better deal, or there's more competition, especially with digital products, telephones, computer services. And I don't know it for a fact, but I've heard that in the past, in the early days of procurement, there were squatters on contracts who would hold it and hold it and hold it, and just this perpetual contracting, especially in the health services area.
And solid waste burning.
Yeah, they'd hold it forever and ever. I've heard it for health services, even attorney services. So I think this is a good thing, and we've always supported it.
What about leases?
I know that there was a law that was passed, what was it, just a couple of years ago, but it's on the leasing of public facilities and land, that if it was going to, that the agency on its own authority, like the airport, can on its own authority lease out land or a public facility for up to 5 years. Anything beyond that has to come down to the legislature for approval.
It's a good policy.
Okay.
I think I kind of raised this before, and I maybe didn't do a good job of explaining it. So the 5-year presumption is good as it's written. In the section before it, on line 5 of 32, it says, unless otherwise provided by law, a contract for supplies or services may be entered into for any minimum period of time determined to be in the best interest of the territory. That insertion of that word minimum, so if I'm an agency and I think the minimum period of time is 10 years, that it seems to kind of be at odds with the 5-year limit, right? So I think we should not have that word minimum in there, because it's a little bit confusing, and I think it would read better if it just said, unless otherwise provided by law, contract for supplies or services may be entered into for any period of time determined to be in the best interests, and then add subject to the 5-year presumption in B.
Where are you?
She's on page 32.
Just
under
above
multi-year
B.
contract.
So it's in A. It's in section A. We've got this odd minimum. So we have B setting a maximum, and then we have this odd insertion of minimum. So I really feel like it should say it can be entered into for any period of time, subject to the maximum.
Consistent with the provisions of this section.
Consistent with B,
But
yeah.
minimum time is...
Minimum is confusing. It's really subject to a maximum.
But it doesn't need to be 5 years. I think that was the
Right.
point that was being addressed here. Is to
Right,
say,
it doesn't need to
It can
be-
be 2 years, it can be 3 years.
Right, it's just...
Which is like in the specifications, where it says that the specification shall include only the essential physical characteristics required to meet the territory's minimum needs.
Right, so minimum period of time makes it seem like, oh, we can set any minimum we want, right? But then B says, no, you have a maximum.
Okay, so
The
we're agreed on the
minimum-
change there, consistent with this section.
Yeah, I
Yeah.
don't object to deleting minimum.
Okay.
And we're going to delete minimum?
Yeah.
Yeah,
Okay.
and then just make it clear that it's subject to the provisions of subsection B,
Consistent with
consistent with the provisions
consistent
of
with
sub-
this section.
Yeah.
Right,
Determined to be in the best.
right.
Oh, so do we still need that determined to be in the interest of the territory?
Yes, because it's,
Consistent with this section,
because you could still make a determination that 10 years is necessary.
so should we say consistent with the section, with
Yeah.
this section and determined to be in the best interest?
Yeah.
Right.
Yeah, that's fine.
Give it a little bit more flexibility.
Mm-hmm.
Okay,
In those rare instances where you want to go longer.
all right. Okay, I think we've pretty much agreed on that presumption of the 5-year limit. And then on lines 10 and 11, again, it was just clarifying that only with the determination made by the Chief Procurement Officer, DPW Director, or head of the agency issuing the solicitation. What was the concern there? OPA.
That was the autonomy issue again.
Agree that
That's fine.
authority to approve exceptional term contracts should be available to DPW and, oh, okay. Yeah, so I think we addressed the concerns of the three. Okay. We move on to page 34. Inspection, right to inspect, section 19, right to inspect plant. And then what we did was, and then, so there was no question there. We have section 20. It's a new subsection. C is to be added to 5241 of Article 3 to read as follows: right to audit records. And this language was provided by the OPA. Okay, any discussion on section 20? Yeah, so I've just repeated the existing language and added on page 35 there, the new paragraph C. The public auditor may conduct or cause to be conducted such other audits of the books and records. Any entity that has procured a contract with the government of Guam or any subcontractor, the scope of such audits shall be limited to the cost, pricing, performance, and payment of such contract.
I think for the, for the contract audit provision,
Yeah,
I think so in the GAR, there's currently, generally, they have to maintain records for 3 years, I think for RFPs. But then there's another section that requires them to maintain their books and records for 6 years for certain types of contracts. I think it might be construction contracts. It's in the GAR. So I'm a little worried that this contract audit provision would trump.
That's not our change.
No.
That's existing language.
That's the existing language. Our change is number C.
Yeah.
yeah.
Our change is C.
To address your concern, though, if there's some conflict, you could just add another phrase to B that says, or such other time period required by regulations or something.
As set by regulations.
I think if there's a conflict between this code section and the regulations
It's the
have to
regulations.
give up.
Right.
That's
they do.
correct.
That's
That's-
what I'm,
And
and
that-
that's,
so,
yeah, I
if
think
you just leave this
there's-
in the law, and then if there's an incorrect statement in the regs, you just disregard that.
Well, I
Well,
think
no,
that
that's
if,
exactly it. So I think,
Because law trumps regs.
Yeah.
yeah. And so currently this kind of trumps so this is an area that we could kind of fix.
So are you saying it should be longer?
So we could, no, we could add language saying,
In paragraph B.
unless otherwise,
Well-
unless a different time limit is set by regulation.
Yeah.
So
here
this
you-
would just create if you have it as it is now, it's just 3 years. And if you have a conflict between the regs that says, ooh, but for this kind of contract, we're going to require you to keep your records for 7 years, your contract records for 7 years.
There's a regulation that says that?
No, if we did, if we wanted to have one, particularly for certain contracts, saying you have to keep your records for 7 years, because there are some federal contract and federal granting issues where they actually want the records to be kept for
Or we could just say for a
6
minimum
years.
period.
Yes. So it could be. So this would set a minimum that all contract records have to be kept for 3 years, unless otherwise provided by the regulations. So
Well,
if you create
And
an
I think
exception.
if we put it minimum, that gives the regulation writer the opportunity to
Yes,
to
for a
provide other
minimum.
instances.
Yes.
So we would make the
Minimum.
change on page 35, line 8, where then it reads that books and records shall be maintained by the contractor for a minimum period of 3 years.
Yes. Yeah, and then
Period of 3 years from the date of the final payment under the prime contract, and by the subcontractor for a minimum period of 3 years from the date of final payment under the subcontract.
and then when it says unless a shorter period is otherwise authorized in writing, or unless a longer period is authorized under the.
Yeah, I think longer is better, not shorter.
Yeah, we don't.
Yeah, and I wouldn't just
No.
put regulation, I would also include law required,
Yeah,
or unless
it's
a longer
required by
period is
law.
required by other law. Because as I
Yes.
recall, there are some actual
are.
federal laws that
Yes.
require you to keep certain types of environmental
Yes.
contracts
For
or,
6-7 years.
yeah.
Yes. So we could improve this by making this a minimum and also accommodating other laws that require longer record
So
keeping.
do we say there on line 11,
Unless a longer
minimum
period.
of 3 years from the date of final payment under the subcontract unless a longer period is otherwise
Required
required?
By
by
law.
other
Right.
law or regulation.
Yeah.
Required in what?
By other law or regulation.
Yes.
Okay. Okay.
Yeah, because we deal with, federal grant money, and so if we have something that says, nope, you only have to have 3 years, but the grant money says you have to have it for 6 or 7, we don't want that conflict.
Okay, so we have no problem in, as a formatting thing, paragraph C should be all underlined, correct?
Yes.
Yes, the format, yeah, that's the new one. And then what other amendments you made in B?
Right. Okay. All right, moving on, section 21. All right, we have 10 minutes till 5. We started at 2, so we pressed on for 3 hours. And we did say that we would end it at 5 o'clock. Yeah, okay. So we could probably, section 21, finality of determination, there was really nothing that was of concern there to anyone?
No, I had concerns
Okay.
about that 21.
Far away.
I wanted the public auditor's determinations to be considered final, and they're not explicitly included under here.
Oh,
I wanted your determinations to be considered final, and they're not
unless the DOT report, right?
they weren't included.
There's
one.
It already says that.
I think there
What-
is,
There's
there's
a-
a finality.
Okay,
Yeah.
no, there's actually a statute that says the decisions of the public, there's a separate statute that says the decisions of the public auditor are final unless they're.
Unless taken up to the
Yeah,
judicial.
Right.
unless they're
Right.
reviewed or under
Right.
judicial review or something.
And all these listed statutes here don't have that finality language in the statute, so that's this kind of pulls them all into the
Yeah.
same
Now,
concept.
if you wanted to include,
I wanted to include those, just so it's absolutely clear.
So it's in the Article 9 section that we'll find the
Well,
Article
language, or
12.
9 or
some
12.
of it's in,
12.
Yeah,
9
some of
and
it's
12.
12, 9 and
12.
12.
Okay.
Yeah.
Yeah, and there's the statute. You know, you go to this, and it says
But
it
actually,
doesn't list her
I-
determinations, right?
well, it says
But then you
except
have
as,
another
if-
statute that says, oh, they are final, but then they're not listed here. So I feel like it just kind of is cohesive.
actually by
if you
including
include
this
them.
finality of the public auditor's decision here, you're changing the standard of review.
Yes.
Because it says they're final and conclusive unless clearly erroneous, arbitrary, capricious, or contrary to law.
Yes.
The standard review for the public auditor is looser than that.
Yes.
Entitled to great weight and
Yes.
something else. So
Yes.
it's the same standard,
we wanna-
unless it's arbitrary, conclusive. I
It's
think it
slightly
has that
different.
same, yeah, it's
entitled to
near.
great weight.
near
No,
this.
this
yeah.
is a deferential
It
standard.
is.
Yeah.
It
This
is different.
is-
Okay,
we-
okay. I
you
don't
know,
have it in front of me
And
right now.
this
Yeah,
is,
so
this
I-
is why
It's
I think
almost
it's-
like it, but not quite.
No, this is a much more restrictive on her decision making.
Okay.
No,
On
no,
her de
no.
novo review process.
So yes.
I don't
and-
think it's a very good idea to put that in here. If it was just making a final, that language is already said. This is a whole different standard of review, and you're trying to
Yes.
take away the standard of review that she's entitled to under the existing law.
Well, this standard of review is more strict, which
Yeah.
makes it harder for the Superior Court to overturn her
Well,
decision.
That's right.
Actually, this standard here, where it says, okay, this is
Yes.
actually what we look to.
Yes.
No,
yes.
when the agency does something, this is what the public auditor
Yes.
looks to and says, okay, is this a final determination? And then, it
And
can only
this
be,
is-
the agency's decision can only be overturned unless it's erroneous, arbitrary, or capricious.
So
Okay,
this
so that's
is-
kind of the standard that we look at.
This is the standard of review that the public auditor applies to the underlying agency decisions. However, when her decision on that goes up to the Superior Court, the Superior Court actually applies a much more lax standard. The Superior Court applies the, she gets weight.
Yes,
Her
that's what the
decision
law
gets
says.
weight.
I think that's a good
And
idea.
so I think
Actually, I think
I
that,
think we would like her decisions to have more weight,
well,
clearly erroneous.
I kind of agree with John here.
Yeah,
We're actually
I don't know about
satisfied with the separate statute
Yeah.
for the public auditor, and that's already clearly spelled out.
Yeah.
Looking at this, this is really more for how the OPA evaluates the agency.
Yeah.
It
Yeah.
is. It is. But
And we don't want to remove the de novo standard for her
Yeah.
to review of the
Yes.
agency either.
That's,
So-
no is the hallmark.
That's the hallmark of it, and the standard
Yeah.
review before the judiciary is any decision the public auditor, including any determination regarding the application or interpretation of the procurement law or its regulations, shall be entitled to great weight and the benefit of reasonable doubt.
right.
Although it's not conclusive.
And this goes with so when I'm saying we want the public auditor's decisions to have this clearly
Have
erroneous,
less
arbitrary,
weight.
capricious, no, to have more weight in the Superior Court. Clearly erroneous is more weight, not
No,
great weight.
it's deferential. Clearly erroneous.
No, it's final. Her decision would be final and conclusive unless it's
What-
clearly erroneous,
That's what
arbitrary,
5704
or
says.
capricious.
And then on top of that, it says great weight. So those are two different things that both
Right.
mention
The great weight standard in the Superior Court is, so currently under how you appeal her decisions to the Superior Court, it's a civil action and a trial, and it's de novo, and technically, because you have a trial, her decision gets no weight because it's a trial. It's a trial. It's de novo. So we are so the position that I've advocated is that it should be by judicial review, which is not a trial, which does not get a de novo fact finding. It is judicial review, petition for judicial review, and under a petition for judicial review, which is usually applied to agency decisions. Their standard is clearly erroneous, arbitrary, and capricious. And we think the same standard should be applied to the public auditor's decisions under a petition for judicial review in the Superior Court, same as it does for the agencies, where her decision is the decision. It's not it's not a trial of fact. It's not a de novo whole new trial. Her decision gets the same weight as an agency decision, and when it goes up for a petition for judicial review, it's reviewed the same way, and her decision gets this kind of weight. Because currently it's a civil action, and when you have a trial of fact, you have a fact finder, and it's de novo.
But
Okay,
adding
but
that
most-
into here would make it redundant, because 5704 already says any determination initial of a finding of fact by the public auditor shall be final and conclusive, unless arbitrary, capricious, fraudulent, clearly erroneous, and contrary to law. So why do we need to add that again? It's already in the statute. And then on top of that, it says her decisions are entitled to great weight, etc.
Yes, but if you look at how is a court supposed to apply this? So I worked at the Superior Court level, and you have this section that says, okay, well, it's a trial, and people are going to come in and they're going to present facts. They're going to come in and testify. You're going to have evidence and witnesses and facts. It's a trial, and in any trial of fact, the judge is the finder of fact for civil trial. And how does the judge consider the public auditor's decision when it is holding a whole new fact situation? The reason we have this very, very interesting dichotomy in how it's heard is because we adopted the ABA model code except for one section. And that section that we did not adopt is a section that said you could either take your agency decision to an entity like the public auditor. It's a different entity in the ABA model code. Or go straight to the Superior Court for a trial. We adopted one where you have to go to her first and then go to the Superior Court, but you have so in the ABA model code, you either could take your decision to the public auditor and she could render basically a final agency decision, or you could go to the Superior Court and have a trial. We mixed it so that now you go to the public auditor, you get your final agency administrative decision, but then afterwards you go to the Superior Court and you have a full trial with witnesses and people that the public auditor never got to hear from, because it's a full trial of fact. And in a full trial of fact, civil action, the trial court isn't they're hearing witnesses and people that the public auditor never heard from. And so they're doing a de novo, they're the finder of fact. Okay. They find the facts. And so we've been advocating that we should get rid of the trial of fact. The public auditor is the kind of the trial of fact, and then her decision can only be overturned on a petition for judicial review, where the court does not find facts, it does not hear witnesses, it does not do all that stuff, and then her decision is only overturned if it's clearly erroneous, arbitrary, and capricious, just like any other administrative decision.
Okay, but that's not done with 5245 in section 21. That's done, you're talking about section 9, or article 9,
and
10,
this section
all the way to
goes
12.
with
Those
that.
are different.
Yes,
Given
in
the
Article
time
9.
given the time now, I would suggest that we will start at section 21 at our next roundtable discussion. And so we will start at section 21. Article 3 ends at section 27. And then I'm also running a comparative analysis on the other half of the document, which compares what we have here now under Articles 9 and 12 with the last version of what was vetoed. The last bill that got vetoed. Okay, now I'm going to go ahead and just recess this, and then after we recess, we just kind of need to get a feel for when's the next available date for everyone. So at this time, then, the roundtable discussion on Bill 162 is hereby recessed. So I guess we need to find out